Welcome back to CSI Coatesville. This is part 2 of a 2-part series on the court system. Specifically today, we want to take a look at the booking process. Now, let's say a crime's been committed. It's reported by someone to the police or discovered in some way. Now, that's typically what occurs. Keep in mind, however, that a crime could be witnessed by a police officer, his or herself, in which case the person would be taken to jail, of course placed under arrest, and bail would be set. Typically, however, that's not the case. So the crime is reported or discovered, the police arrive, they conduct an investigation, and the crime scene is processed, a suspect is identified, the FBI, the DEA, and so forth, other agencies may process some of that evidence, as well as the crime labs. And then probable cause is determined. In other words, there's sufficient evidence to take to a judge and an arrest warrant is going to be issued. Next, that person's placed under arrest. Again, they go to jail, bail is set, and they appear before a judge in a procedure known as an arraignment. What is an arraignment? As you can see, it's a criminal proceeding at which the defendant is officially called before a court or competent jurisdiction, informed of the offense charged in the complaint, information, indictment, or other charging document, and asked to enter a plea of guilty, not guilty, or otherwise provided for by law. Okay? And then the process, the legal process will continue from an arraignment. Now, this is going to depend upon the seriousness of the crime. If it's a felony, you can see we'll follow down this series of events. If it's a lesser crime, a misdemeanor, there's a pretrial arraignment where a trial date is set, and then we go to a brief trial. Now, keep in mind, however, that over here, charges could be dropped or dismissed, so we want to keep that in mind. If there is insufficient evidence to go forward to a trial, the judge is going to dismiss the defendant. And then, as you can see, we go through the legal process for a felony, a preliminary hearing. Sometimes a grand jury would be set, in other words, to gather evidence to determine whether there's sufficient evidence against a defendant to go forward with a trial. Pretrial arraignment is planned, and then a trial date is set where the evidence that's provided in this case is presented, so both sides and the court are informed of the evidence that's against the defendant, and then we move ahead with the trial. Now, keep in mind, at a trial, there's two possibilities. A person could be convicted, in other words, found guilty, or they can be acquitted, which means that there's insufficient evidence to convict that person beyond a reasonable doubt. And then after that is a sentencing hearing in which the person could appeal the sentence, arguing that the sentence itself is unreasonable. And then a person is going to go to prison. Now, here's some questions for you to consider. When and under what conditions is an arrestee fingerprinted? For what reasons might a defendant's attorney file an appeal? What does an acquittal actually mean? Is it the same as being declared innocent? And what does probable cause mean? Here's some questions for you to consider. Again, thanks for watching. Bye-bye.